Hello everyone. We'll start in like 2 minutes. We are waiting for some other people to join. There are a couple of more registrations that had happened, so we'll request all of you to be a little patient. We'll start in the next 1 or 2 minutes at best. Good afternoon, everyone. A very warm welcome to our legal A to Z session on starting and sustaining an NGO, registration and FCRA requirements. I am Karuvaki Mohanty, Program Manager at iProbono India. Before we begin, I'd like to take a few minutes to quickly introduce iProbono India to all our participants today and also our speaker for today. We are a social justice organization dedicated to enabling people to access their rights. Our work began 11 years ago, and since then, we have significantly expanded our scope. Today, we not only provide pro bono litigation, but we also offer comprehensive care. We take on advocacy efforts, and strengthening civil society is also one of our core areas of work. And direct legal support, which comes under strengthening civil society, is something that we are committed to. And we provide this through our very dedicated and committed pro bono legal advisory lawyers. And the assistance that we provide to NGOs through this network of accomplished pro bono lawyers includes crucial advisory services on like regulatory compliances, contract drafting, assistance with intellectual property matters, so on and so forth. One of the most significant themes we encountered last year was the high volume of requests we received, which concerned establishing NGOs, how to basically bring up an NGO, how to form an NGO, the necessary statutory requirements that must be followed, how can one navigate complex FCRA requirements and ensure that their NGO gets uninterrupted funding, because that's what is required when we are actually in the civil society space. We require funding to carry on with our programmatic work. This overwhelming need is why we are hosting this webinar today. I am delighted to introduce Ms. Ranjini Gogoi as a speaker today. Ranjini is one of our esteemed network lawyers who will guide us through these requirements. She's an experienced lawyer, qualified in India and England and Wales, with extensive hands-on advisory experience in non-profit formation, FCRA and complex regulatory environments. She has in the past also advised our partner organizations on their FCRA requirements and formation of NGO queries. Ranjini, thank you so much for so kindly dedicating your time and expertise to this session and agreeing to do this pro bono. We are truly grateful. In the end, I would like to bring up some housekeeping rules, a few quick notes. The main session will run for 1.5 hours, followed by an additional 30 minutes dedicated just to question and answer. So you can, raise your hand or unmute yourselves and ask your questions. You can also put down questions on the chat box through the session if you think you'll forget. Our team will collate those questions and in the end for Anjali to answer. We kindly request all of you to keep your phones and microphones on mute throughout the presentation so that there's no disturbance. And we strongly recommend people to ask questions and look forward for this session to become a little interactive towards the end. And we'll also be happy to take on your suggestions going forward how to make this better. In addition to this, I would also want to say if there's anyone who doesn't understand Hindi, हम हिंदी में ट्रांसलेट करने की कोशिश करेंगे कुछ कुछ पॉइंट्स और हम चैट बॉक्स में कोशिश करेंगे कि जो थोड़े से डिफिकल्ट डेफिनेशंस हैं या क्लॉजेस हैं वो हम चैट बॉक्स में हिंदी में डाल दें ताकि अगर यहाँ पे कोई है जिनको इंग्लिश समझने में दिक्कत है तो वो उसको पढ़ के समझ ले इन केस बोलते वक्त भी आपको जरूरत है कि हम कुछ ट्रांसलेट करें सो यू कैन प्लीज गो ahead and tell us that on the chat box and we'd be happy to stop and translate those portions in Hindi for you. Saying that, I would like to hand over to Ranjini now to begin the session. Ranjini, please go ahead and please feel free to share your screen and start the session. Thank you.
Hi, everybody. Am I audible? Yeah, so I'm just sharing my screen. Yes. Is it visible? Is my screen visible? Okay, sure. Yeah. Hi, everybody, and thank you, Karuvaki and Amla, for giving me this opportunity to speak today. And thank you for the very kind introduction. I don't think I need to repeat anything there, so I can just head straight to the content. So the purpose of today's session is actually twofold. This is to walk everybody through the various types of nonprofit entities in India. What are the key differences between these nonprofit entities? And what are the pros and cons? How do you register? What are the things you should keep in mind when you're deciding what kind of an entity to set up? That's the first part. And the second part will focus exclusively on FCRA. So essentially, what is FCRA? Because it's a word that we hear a lot. What are the requirements? Who it applies to? And what kind of what is a foreign source? What is a foreign contribution? How do you register? And what are the ongoing compliances that you would need to keep in mind once you have registered for FCRA? So without further ado, I think I can start. So essentially, there are three types of nonprofit entities in India. One is a society, which is governed by the Indian Societies Act. One is a Section 8 company, which is just a charitable company. It's governed by the Indian Companies Act, and it's the formation, the manner the organization is very similar to a private limited company, but the difference is that it must have certain it must have certain requirements to be classified as a Section 8 company, and the compliance regime is slightly less onerous. The third is a public charitable trust, the third is just a public charitable trust, which is a trust formed for the benefit of the public. And it's different from a private trust, which is governed by the Indian Trust Act. Sorry, am I frozen?
No, Ranjini, we can hear you.
Sorry, my screen is not moving. Yes, it's moving now. Yeah. A society is basically just an association of seven or more people, and you must who are united to for a common purpose. And the common purpose must be promotion of literature, science, fine arts, any charitable purpose, or any other useful knowledge or a public purpose. It has legal status as a body. It's not a it has legal status as a body, but it's not a body corporate or it's not a company, which is even though the manner of working is very similar to that of a company. And a society can be formed by seven members or more. But if you want to have a national level society, then there must be eight members, and each member must belong to a different state. So basically, for a national level society, there must be representation from multiple states of India. You cannot have six people, seven members, all from Uttar Pradesh, and then call yourself a national society. A trust is slightly different in that it is a body which is established for the benefit of the general public, not for specific individuals. And it serves a charitable purpose or a public purpose, like providing support for poverty relief, providing education, healthcare, etc. In India, a trust can either be a public trust or a public charitable trust or a private trust. A public charitable trust is governed by state specific laws. So, for example, in states like Maharashtra or Gujarat, where you have a charity commissioner and you have specific state laws, the the registration of the trust will be governed by that, and all aspects of the trust will be governed by that. But in other states, for example, Karnataka, where you don't have a state law, a trust is not really governed by any.
Ranjini, I think we lost you. Hello, everyone. I think we lost Ranjini. Just give us 1 minute. We are trying to get in touch with her.
I'm trying to get in touch with Ranjini. She's trying to join back. Just give us 2 minutes.
Apologies for this, everyone. There's some connection issue at Ranjini's side. She's out of India actually. That's why the problem. She's trying to join back ASAP. So just would want all of you to have a little patience. We'll try to get her on as soon as possible. She actually didn't realize that it got disconnected, so she's taking a little bit of time. Hi, Ranjini, can you hear us? You're on mute.
You are on mute.
Yes, I think I'm muted. Unmuted now. Yeah. Hi, I'm so sorry. I didn't realize I had dropped off, so I was still speaking. So I'm not very sure where exactly I dropped off, but I think Amla tells me I was at the definitions. Is that correct?
Yes, right. Right. You
Okay,
can
sure.
start from start from there.
Okay, sure.
From Section 8 company, maybe.
Okay, sure. Thank you. Yes. So a Section 8 company is very similar to a private limited company. The key difference being that it must have in its objects, it must have been formed for the purpose of promoting art, science, commerce, education, or research. It cannot pay dividends to its members. And the third is it must apply its profits or its income in promoting its objects. So one key concern that a lot of people have when they talk about Section 8 company or any charitable entity is, are they allowed to make a profit? Because the term non-profit to a lot of it essentially seems that you can't make a profit, but that's not the case. It's a Section 8 company or even a society or a public charitable trust. The purpose is you're allowed to make a profit, you're allowed to have income. The thing is your income must be applied towards your objectives. So for a Section 8 company, you cannot give dividends to your members. All of your profits must be reinvested into your objectives, and if you don't, then you're in non-compliance and you will lose your Section 8 company status. And we will talk about this a bit later, but this is also one of the essential requirements for maintaining your tax registrations under Section 12AA of the Income Tax Act. Here, I think I will ask Amla and Karuvaki if there's anything they need to add before I move on.
We are adding the definitions जो हिंदी में हम ऐड कर रहे हैं चैट में. अगर किसी को कुछ समझने में मुश्किल हो रहा है तो प्लीज आप लोग पूछ लीजिएगा हमसे. Go ahead, Ranjini.
Sure, yeah. Now, so some of the key differences between a society, a trust, and a Section 8 company are, one is, of course, the governing law, which I have already explained. A trust will be governed by your state laws. And if there is no state law, then there is, if a state doesn't have a specific public charitable act or a law on public charitable trusts, then essentially there is no one act governing a trust. And that is one aspect which becomes very important from a compliance perspective. Section 8 company, again, is Companies Act. So a society can have 7 members, a minimum of 7 members. And if you want to have a society, if you want to call yourself a national level society or a pan-India society, then it must have 8 members from various states. A trust can have 2 or more members. A Section 8 company, again, it must have 2 shareholders. I think a company, everybody knows you will have shareholders who are essentially the owners of the company. They own shares in the company. And you will have your directors who are the governing body of the company. They are the ones who run the company. They do all of your day-to-day compliances. But the actual owners of a company are the shareholders. For a trust, the governance is by trustees, because a trust is essentially just a group of people coming together and agreeing to hold some property for the benefit of the public. For society, the governance mechanism is similar to companies in the sense that there are 2 bodies, or there are 2 levels. One is the general body, which is like your shareholders. They are just the members of the society, but they are not in charge of day-to-day governance of the society. The second is the governing body, which is like your board of directors. So if most of your society's regulations, your society's memorandum, the rules and regulations will have different requirements if you want to pass certain resolutions. So it's exactly like a company. Some things can be done by a resolution of the board of governors or the governing body. But for other things, the key aspects like dissolution of a society, or admitting new members into a society, or changing the objectives of a society, for that, you would need a resolution of the general body. The requirements differ. The law doesn't really, Societies Registration Act doesn't really specify exactly which aspects need approval of the general body and which aspects need approval of the governing body. But the members of a society have the freedom to decide this in their own memorandum and their rules and regulations. Similar with a Section 8 company, where certain actions can be taken by a board of directors. You don't need to call a shareholders meeting again and again. Whereas other more material actions, and like a society, dissolution of the company, or you want to change the nature of the company from a Section 8 company to a private limited company, or you want to infuse more capital, some of these actions will need approval of the shareholders. The difference being that in case of a Section 8 company, as items which need board approval and items which mandatorily require shareholders' approval will be set out in the Companies Act. All of these 3 entities are eligible for FCRA because the requirement for FCRA is that you need to be a non-profit. There is no difference, but generally, from the perspective of a foreign donor or a foreign contributor, a Section 8 company is a bit more preferred, and why we will come to in a few minutes in the next slide. The constitutional documents for a trust are just the trust deed. For a society, it is the memorandum of association of the society. And that's a very simple document. It only has the objectives of the society. It has who were the initial general members of the society. It will have, I think, what the minimum paid in capital was. So it's a very broad document, just setting out mainly the objectives or the broad contours of the society. But the actual day-to-day working of the society, that's set out in the rules and regulations. For a Section 8 company, you will have the Memorandum of Association, which again is very similar to the Memorandum of Association of a society, which is that it will have the paid-in capital, it will have the objects of the company, it will have the location of the company and things like that. Whereas the Articles of Association will actually have more details as to how the company is to be run. In case of property, any property owned which devolves into the society has to be held in the name of the society. For a company, it has to be held in the name of the company. But for a trust, it has to be held in the name of the trustees. And the reason being that the trust is not a separate legal entity. It is just a body that has come together to form the trust. If you have registered yourself as a society, now, even though societies are governed by the central legislation, which is the Societies Registration Act, most states have passed their own amendments to the Societies Registration Act, which means registration requirements for every society will depend on what state you are formed in. The core requirements are very simple. You have to have your memorandum of association. You have to have your rules and regulations. You would have your general body appointed. You would have the objectives set, and you take all of this documentation and you file with the Registrar of Societies. Now, here it's important to remember that there is no one registrar of societies. It will depend on every district in every state. So in Delhi, for example, different parts of Delhi will be governed by different registrars. So and I have seen instances where sometimes societies are formed and they register themselves with the wrong registry. And nobody says anything, they are registered. But then when it comes to making their annual filings or when somebody investigates, it turns out that they were under an incorrect registrar all along. So they're technically non-compliance. So it's very important to understand exactly what registrar your society, your locality falls under, so that you're able to register yourself and do all your annual compliances with the right entity, with the right authority. So the core requirements, it does not take very long, but the core requirements are the same. Because it is so state specific, a society, you need to there are certain local requirements, and this is not something which will be set out in the act or in the state act itself, but you would need the help of a consultant to help you set up. So a consultant who's used to setting up a society, who does this day to day, will know exactly what the requirements are. Because sometimes some registrars or some states, they have very specific formats that they like, or they have very specific things that they want to see in the memorandum or in the rules and regulations. This is why even though a society has relatively less compliance than the Companies Act, sometimes setting up a society can be a little bit more opaque or a little bit more difficult than setting up a Section 8 company. For a trust, if it's a trust which is not in Maharashtra or Gujarat, it is in a state which does not have a Public Trust Act, it is the easiest to form. You need a trust deed, and you go register you pay the stamp duty and you register the trust deed, and that is it. It's done. So which is why for smaller NGOs or any NGO which is just starting or which has capital, financial considerations, a trust is sometimes the easiest to form. And because in states where a trust does not have, where there is no trust act, there is no annual compliance either. So you can simply delete the cost of compliance from your budgeting or your administrative expenses. So that is a huge advantage that is given that trusts have when it comes to smaller NGOs. A company, the registration process is, again, it's set out in the Companies Act, and it is a little bit more onerous because it's exactly the same, not exactly, it's very similar to setting up a private limited company, which means you will have to you will have to reserve the name first with the ROs, with your specific registrar of companies. Then you will have to collect the necessary documents. You will have to have your articles of incorporation in place. You will have to have your memorandum of your MOA in place. You would have to have appointed your directors. You would need PAN numbers. You would need the registered office of the company. You would need to very clearly specify the objects of the company. And then once you've collected all the documents, the process itself is simple in the sense that you file the eSpice form. Nowadays, all incorporation of companies can be done online. And it's actually a very easy online process. It's standardized, but the process of the actual collection of documents is something which may take some time. Between the three, a trust is actually the easiest to form. So for anybody who has concerns regarding compliance, a trust would be the best entity. A company is not the easiest to form, but the process is very, very standardized because it's set out in the Act. And unlike the Societies Act, the Companies Act is a national level legislation. So there are no state amendments to it. So irrespective of what state you are formed in, the process for incorporating the company will be the same. And it can be done online, which means it is very easy. A society, because it's not an online process, requirements may differ depending on the local registrar and the relevant state. Sometimes establishing it, even though on paper it is very straightforward, sometimes establishing it may be a little bit more time consuming, or a little bit more difficult in the sense that there is sometimes no clarity as to how exactly to set it up. Annual compliances, again, for a trust, it's very low. For a company, it is high because you have to submit your annual returns and your accounts to the registrar, to the registrar of companies every year. For a society, there are certain filings that you need to make with your registrar, but the requirement is not as high as a company. And the consequence, so if you don't file the annual returns or you don't make your annual filings, the consequences are less than what would be for a company. Tax registrations, again, under Section 80G and Section 12AA or Section 12AB of the Income Tax Act is permitted for each of these entities, because again, the key consideration is that it must be an entity formed for a charitable purpose. And once you have your 12AA registration, this is something which a lot of entities miss. You will have annual compliances. So you need to file certain things with the income tax authorities or the relevant authorities designated in your tax certificate. So once you get your tax registration, you will get the 80G registration certificate, you will get the 12AA certificate. There would always be conditions written down there. So if you change your members of the society, for example, or you change the trustees, or you change the objects, or sometimes if you revise your constitutional documents, all of that you would need to notify the relevant authority. And in a lot of due diligence exercises which I have done in my as a lawyer, I have very rarely seen companies or societies or trust anybody. I have very rarely seen anybody 100% being 100% compliant with this, because this is a requirement that people simply miss. You get your tax certificate and it's nobody ever looks at it again. But it's not as simple as that. There are certain conditions you have to meet, and there are certain compliances which you have to do. It's not an annual compliance, but there are triggers, and if you meet those triggers, you would have to notify the relevant authority. Theoretically, if you're not complying, then your registration can be revoked. It has every 12AA certificate that I have seen says the same thing. If you don't comply with any conditions set out there, they will just cancel your registration. But in practice, it's not something I've seen happen very often. So theoretically, yes, if you're not careful about these compliances, the risk can be very high. But practically, it's not. I mean, tax registrations are not usually cancelled at the drop of a hat. Then here. Now, I mentioned earlier that a Section 8 company is from the perspective of FCRA, is highly preferred. And the reason is because it is one of the most credible structures it's one of the most credible structures to form a body corporate or to form an entity. It is very well known. It is a charitable company and it's structured exactly like a private limited company, right? The difference is only that you can't pay dividends to your members and you have in your objects, you have a charitable purpose. But in every other way, organization, compliance, transparency, it is exactly like a company. So it's very, and because the registrar of companies maintains an oversight over it, because your compliances are so high, annual compliances are so high, it is it is a very, very transparent structure. So if you have a foreign donor, this is the entity that they prefer the most. They're very comfortable with it. They know exactly what is going on because as a shareholder, they have rights. They can get they have rights to certain information. They have to approve the annual accounts of the Section 8 company. They know that compliances are being made because it's in India, it's very easy to check. You can simply go to the website of the Ministry of Corporate Affairs, file for public documents, and all filings that a company has ever made, including its articles of incorporation, will come up there. Governance norms, again, are very, very established, which means that they are standardized. The Companies Act is very clear, it's very coherent. There is usually no ambiguity or ambiguity as to what is, how to govern, or what are the items that need a director's resolution, or even questions like how to infuse capital, how to fund a Section 8 company, or something like how do you fund a Section 8 company, or what are the activities a company can do, or how do you pay you can't pay dividends. How do you can you accept deposits or not? All of these questions are very clearly answered. So they have very established governance norms, and all of it makes it a very attractive vehicle for a foreign donor. And again, the structure of a private limited company or a charitable company is very similar all over the world. So this is not something that needs explaining. There are no nuances usually that need explaining to a foreign donor. So which is why this is the most preferred form. And they also almost always, they can maintain a high degree of oversight over a Section 8 company. The other benefit, of course, is because it's a company, it's limited liability. And limited liability essentially means that the shareholders or the members of the company are different from the company itself. So if I am a member of a company, or I'm a shareholder of a company and I have put in 100 rupees, and somebody else has put in 200 rupees, then my liability is limited to the amount that I have put in. So if the company, for example, there is an issue, the company has a creditor, or the company has taken any debt, or the company is wound up or dissolved, then nobody can come after my private assets. A creditor can only come after the assets of the company, and my liability will be limited to whatever amount I have put in. This is not a benefit that you get in a society or a trust. On the other hand, setting up a company can be a bit time consuming, and dissolution, winding up a company is most certainly time consuming because you have to follow a very set procedure which is set out in the Companies Act. Compared to this, a society is relatively easy to govern. It's easier. Again, it's a bit time consuming because the formation is a bit time consuming because of practical considerations. But theoretically at least, and especially if you have a good consultant, if it's in a state or a registrar which is very used to dealing with charitable societies, then it can be formation can be easier. Dissolution is also extremely easy. You need, if 3/4 of the general body of the society agree to dissolve or wind up the society, then yes, it can be dissolved very easily. There are annual compliance requirements, but it is not as high as those of a company. And a society is also a structure which can give comfort to a foreign donor because the management structure is very similar to that of a company. There are two bodies. One is the general body, one is the governing body, as we discussed. Then the documents to form a society are similar to the documents which are needed to form a company. So, because there are similarities between a society and a company, it can also give some comfort to a foreign donor. The main issue with a society, and it's the same as the issue for a trust, is that there is a lack of transparency. Because there is no law which says what kind of information you must give to your general members, or what kind of information you must make public. Nobody really knows how a society is being operated. And more importantly, it's very difficult for a donor to understand exactly where their funds are being used. For a company, as I have said, all records of a company can be made public, even for a charitable company. But for a society and a trust, no document is made public. So you have to, so if you want, so if I want to see the articles of the society, or the memorandum of a society, I would have to go ask the society, or I would have to go physically to the registrar's office to see the documents. But it's not something which is generally available otherwise. A trust, again, of all the three entities, a trust is the easiest. So and because there is no law really governing it, it gives you a lot of flexibility. Sorry, for society to be a registered and a recognized society in India, there are certain requirements. The Societies Act said you must have certain objectives. The Societies Act is very clear. It must be a philanthropic objective, or educational, or healthcare, or cultural, or a sports activity. So you can only be a society if you a recognized society in India if you meet these criteria. Same for a Section 8 company. It has to have a very definite and clear objective to promote any cultural activity or educational activity, etc. On the other hand, for a trust, there is no such requirement. So basically, you can form it for whatever the purpose of the trust, or the objective of the trust can be whatever is written in your trust deed. And that gives you a lot of flexibility, especially if you're starting as an NGO for the first time, and you want to have more flexibility as to what exactly your objectives would be, or what your purpose would be. Then a trust may just be easier. Another benefit of a trust is there is literally no compliance cost. So it is very, very cost efficient. Your administrative costs will be very less. And registration, when we talk about registration of a trust, it essentially just means registering the trust deed. And if you want to get your income tax registrations, ATG and 12AA, then those are the registrations. Otherwise, there is no body which will regulate a trust. Of all three of them, how to decide what kind of a nonprofit you want to form will really depend on what is it that you want to do. If you want to scale up, if you want funds from abroad or foreign donors, then it's always better to go for a Section 8 company. And yes, the initial cost may be a bit high, but in the long term, this is something which will give you more stability, because more credibility, more stability, and it will also help you attract more foreign donors. Yes, Karuvaki, sorry.
Thank you, Ranjini. Sorry for cutting you, but just because we are on discussing which form of whether we should go for a Section 8 society or trust, this is the question that we've received the most during this one past year. Also before, like, we get this question a lot for smaller companies, smaller NGOs that want to start up, and try to build something. Like as per your suggestion, you said that if you want to keep it flexible, then we go with trust. And if you
Exactly.
need FCRA funding, then it's better if we have an Section 8 company because it's more compliance heavy, and
Yes.
that's why it will be
Transparent.
better. So what about domestic funding? Do you have idea as to when it comes to the domestic funding scenario, the grantees,
Mhm.
what should they go for? And do you think in that case also Section 8 company is important? And if at all we go for a Section 8 company, does an NGO need a third party, audit firm or a CA agency that they should have in place that they can take help from? Or will people who are, just doing the programmatic work, like, for example, I'm a program manager, I really do not know how my organization does take care of the compliances bit. Similarly, if
Mhm.
maybe there are 5 people in an NGO or say 10 people who do not know how to take care of the compliances, will
Yes,
an
yes.
additional body help them? How do they go about it? Because it seems like the compliance norms are actually onerous when it comes to a Section 8 company.
They are, they are. I wouldn't say onerous, but they are a lot. And there are consequences if you don't meet compliance norms because it's the Indian Companies Act and MCA is strict about compliance. So thank you for the question, Karuvaki. I think it is very important. For domestic funding, there is, I have, at least in my experience, I have not seen any preference for any type of entity because anybody, in fact, I have actually seen a lot of donations go to society and a trust because in India, at least, and generally the world over, societies and trusts were more established, more older forms of nonprofit. So when people think of a nonprofit, even today, a lot of bodies, a lot of entities, they think of a society or a trust. They don't automatically think of a Section 8 company. And because donations, I mean, I think donations in India are not really regulated unless it's a political donation. It's just a grant which comes in. And sometimes you won't even have a grant agreement. It's just a matter of donating the money and getting the Section 80G exemption. There's no one preference. It's of course there are donors who want more control over where the funding is going, where the financing is going, but usually there is no preference. Now, here it's also important from a CSR perspective. If you are an NGO or a trust, if you're an NGO that's receiving CSR money from a company, then yes, then there would be a greater accountability requirement because nowadays in India, the CSR compliance is very high, which means it's not enough for a company to simply donate. They have to make sure they have to have a plan to see where the CSR funds are being used. They will have to have a committee to deploy funds. They will have to get reports from the NGO that they have donated money to. And the NGO must be something known as an implementing entity, which is that you must register yourself with the Companies Act as an implementing entity. Now, for CSR, because again there is greater oversight by the donor, perhaps a Section 8 company would be more beneficial, but I have not really seen any preference. So if you only want to attract domestic funds, you want flexibility, then perhaps a trust is something that you could consider. It is the easiest to form and easy and relatively easy to dissolve. For the compliance, having a separate audit firm or a CS firm or an accountant firm, I have seen a lot of groups which maintain this because sometimes it turns out to be easier than having your own internal CS or own internal accountant, and sometimes it may even turn out to be more cost efficient. But it is recommended, yes, especially for the beginning because there are so many forms and there are so many forms, there are so many requirements. And even when you're getting funds from abroad or from domestic sources, there are I mean, a Section 8 company, a lot of times funds may come in as capital infusion, where somebody is just putting money in your company and they're becoming shareholders or they're becoming debt. But in all of this, there are certain requirements that you need to fulfill. Any funding for a Section 8 company has to be done as per the Companies Act. So, and for all of this, sometimes, yes, it is helpful and easy to have a CS. In fact, I would suggest my experience has been if NGOs, uh, it's recommended that at the time of setting up itself, someone should take help from a CS or a consultant. Basically, a consultant or a CS, somebody who knows how to register, what the compliances are, and what are the pitfalls that NGOs often fall into. You don't have to maintain, you don't have to keep a CS as retainer. But at least at the beginning, when you're registering yourself, when you're forming yourself, it's always helpful. And yes, it is a little bit costly, but in the long run, this may be something which is beneficial, because then your registrations, your incorporation, your basic structure is in place. Karuvaki, does that answer the question, or do you think there's anything else that I should address?
No, Ranjini, thank you. Please go ahead.
Sure, yeah. So again, as I said, if you for smaller entities, which maybe somebody who's not really looking to attract foreign funds, somebody who wants flexibility in how to operate, a trust may be the better structure, and it is also the most cost efficient. So you could consider that. But if you want to scale up, if your idea is that you want to become a bigger NGO, you want to you want to say perhaps one day operate a school for the underprivileged, or you want to operate in multiple states in India, then a Section 8 company will give you the best foundation for scaling up, for attracting funds from foreign donors. And so this is it really for the Section 8 company on the different types of nonprofits in India. And if somebody has any question, perhaps I can take a few now before we move on. Or if somebody wants me to explain something again, maybe I can pause here and take a few questions, if that's okay.
Ranjini, we do have some questions on the chat box about the formation. Maybe we can do that now, and for the FCRA bit, we do it in the last. One question by Edlin is, can a trust work on a pan-India level?
Yes, it can. Yeah. There's nothing stopping a trust from working at a pan-India level. You can work there, but it's important to keep in mind where you want to register yourself. Registration should ideally be done in a state where you have where in a state where the compliance is a bit easier, and in some states there could be requirements where they say that like for example, it depends on the purpose of the trust. For example, if you're starting a trust to operate a school, then some states have a requirement that the trust must have been established in the state where the school is going to run. They would not accept a trust set up in Kolkata running a school in perhaps Karnataka. I know Karnataka has this requirement. So really depends on what is it that you want to do, but by and large, there isn't any restriction.
Thank you. Ranjini, the next question is, what are the allowable income generating activities available to the three entries? For example, grants, donations, memberships and subscriptions, sale of goods, provision of services and investments. Do the three types of entities differ in whether they are or are not allowed to generate these kind of incomes? And in terms of caps and amounts that can be earned and received? It's already, the question is also there in the chat box if there's
I
any
can see
clarity
it,
that you
yes,
need.
yeah. So yes, so all of these memberships and subscription, I think membership and subscription is something which will depend on the nature of the entity. So if you're a society, you will have a membership and you will have members and membership fees. But that's a very nominal amount. That's usually not a big amount, because a society does not generate income. A charitable society does not always generate revenue or income from its members. It gets its money, primarily it gets its funding from grants and donations. Investment is something that I would have to, I don't think investment is, because this is more of a tax question, not a legal question, but investment is not something that I've always seen. A trust which has a charitable tax registration, I don't think an investment is something which they can do. A Section 8 company, perhaps, yes, but a trust and a society, I'm not really sure. I do know that there are certain restrictions under tax laws, but yes, but no, I'm not entirely sure how much they're allowed to do this. Grants and donations, yes, they can receive grants and donations. And sorry, receiving investment, that's permitted only for a Section 8 company, of course, not for a trust or a society, because by its very nature, investment means you've contributed to the share capital. So by definition, it's something which can only be received by a Section 8 company. Grants, donations can be received by everybody, by all three, and all three can also make grants and donations. Sale of goods, provision of services, again, there is no restriction as such. As I said, there is no restriction really on what kind of income can be generated. The requirement is that the income must be reinvested into the object. So if whatever money you have made, it cannot be distributed as a service fee. It's ideally 85% of your income at the minimum must be used for your operations. Again, if it's domestic sources, then no caps as such. If it's a foreign source, then again, your FCRA regulations would apply. Your FCRA would be given, if it's an FCRA registration, then no caps as such. But if it's an FCRA permission, and we'll come to the difference between the two, then yes, the cap would be whatever the permission letter says.
Thank
This
you,
is
Ranjini. Sorry. Please go ahead.
sorry. Go on. Yeah. No, I was saying this is one of the last questions now. Before then we can just move to the next topic. This question is, under which law a society can be registered at the national level with 8 members?
It's same Societies Registration Act. And depending on which state, it'll so you can have a national level society, but you can register yourself in any one state in India, and the registration process would depend on the specific state requirements of that state or the state amendments to the Societies Registration Act. But the overarching law is the same for all societies. Yeah. So no, I think I'm just seeing the next question.
I think
There cannot be.
Ranjini, and I think we can come back to these questions because then otherwise we won't be left with much time.
Yeah.
Or do you want to take the last question in terms of can an existing society be converted into a Section 8 company, or can we register new Section 8 company with the same name?
No, so there are certain restrictions actually, and a society can be merged into another society having similar objectives. A Section 8 company, the merger process restructuring is simpler. For a society, there is a provision theoretically, but it's not something I've really seen in practice. But yes, theoretically, it cannot be converted to a society cannot be converted to a company. It cannot be merged to a company with a company, but it can be merged with another society which has similar objectives. And I think there was another question which was, is there a provision where instead of minimum 7 members, can they only have 2 members like a trust? No, that's not allowed. A society needs to have a minimum of 7 members. So which is why a trust sometimes is the easiest. You just need 2 people to form a trust.
Thank you so much, Ranjini. I think that's about it for the questions in this section. There was two questions actually. Can you please share your presentation? So we have a recording of this entire presentation that we'll put up on a YouTube channel. We can share that with you later, and also like maybe come up with like something like a small 2-pager or a note or something that we can share with the group if they are interested. Over to you, Ranjini. We can start with the FCRA section.
Sure. Now for FCRA, this is something that I think everybody hears a lot of. Everybody talks about an FCRA registration. And in the last couple of years, there has been a lot of news about FCRA registrations being cancelled, or raids being done on FCRA entities on grounds that they are violating the terms of the FCRA. So the question is, what really is it? It's a law known as the Foreign Contribution Regulation Act. And basically, it regulates or it controls donations or grants into India from foreign sources. There are very specific definitions of foreign contribution and what is a foreign contribution and what is a foreign source. But before we get there, which entities are regulated by FCRA? Basically, any entity which has a definite cultural, economic, educational, religious, or social objective will fall under FCRA. And such an entity, essentially a non-profit or an NGO can only receive money from from a foreign source if they are either registered with the Ministry of Home Affairs under FCRA, or they get permission from the Ministry of Home Affairs for the foreign contribution. Now, what is a foreign contribution? For example, if a society is providing services to a foreign body, anybody, any non-resident or somebody, a person or an organization or a company, and then they receive service because they're providing these services, they receive service fees. Would that be foreign contribution? And the answer is no. A foreign contribution must be a donation, a delivery, or a transfer made by a foreign source. And now I know that the wording is very broad because technically everything is a transfer, right? You receive service fees, it's a transfer. You receive an investment, it's a transfer. But the Supreme Court has actually defined the foreign contribution, has read foreign contribution more narrowly to say that there must be an element of, there cannot be an element of quid pro quo. So service fees, because you're not getting it for free, it's not a donation. And you're only receiving service fees because you have provided these services, will not be foreign contribution. It must be a grant. It must have an element of charity. An element of philanthropy. It must be a grant or a donation or something that you're receiving for no consideration. And that is the key part of what forms a foreign contribution. Service fees or remuneration, even salaries will not be foreign contribution, but a grant or a donation will be. Now, here the next question is, what about a Section 8 company? Because it's a company, it can receive grants and donations, but it can also receive investments. And an investment has an element of quid pro quo, right? An investment is not something anybody is getting for free. In exchange for the investment, they're getting shares in the company. So where does that fall in? And for a while, this was a very ambiguous area of law. This was a question which used to come up again and again. And if you look at the definition of foreign contribution, if you look at the way the Supreme Court has defined a foreign contribution, investment into a Section 8 company should not fall under FCRA. But the Ministry of Home Affairs has actually released their FAQs on their website, and perhaps Amla Karovaki, after this session, we can perhaps share the link to the MCA FAQs, and because that does provide a lot of clarity. They have very specifically said that even if you make an investment into a Section 8 company as a foreign resident, that will fall under FCRA. So usually, if a foreign if a foreign investor wants to invest into India, there is something known as it'll be foreign direct investment or foreign portfolio investment, and there are specific laws which govern, but those are easier laws. They're very easy, low compliance requirements. They're very standard. But if you're a Section 8 company, then any investment that you receive from a foreign source will not fall under the FDI or FPI regime. It will actually it will become a foreign contribution. And this goes against the very idea of what a foreign contribution is, but that is just how the MHA has interpreted for it. That is just how the requirement that MHA has set up. So even if you're a Section 8 company and you're receiving an investment, not a grant, you would still need to comply with FCRA. A foreign contribution, it does not only have to be money, it can also be any article, it can also be a security. Now, what is a foreign source? And a foreign source is basically anybody. It's very widely defined to see any citizen of a foreign country, any society which is set up in a foreign country, a foreign government, of course, an agency of a foreign government, a foreign company, a multinational corporation sometimes, a trade union which is set up in a foreign company, or even a foreign trust, a foundation. Even a foreign trust is a foreign source, but also a trust in India, which is mainly financed by a foreign country, that would also be a foreign source. And very importantly, if a company under the Companies Act, if 50% of your share capital is held by a foreign source, then that would also fall under the definition of a foreign source. So basically, a company in India where 51% of the a company in India where 51% of the share capital is held by a foreign resident, then technically it can still fall under it can still be a foreign source. But here, actually, MHA has clarified that if if the Indian company, if they are complying with the FDI regime, then it will not be considered to be a foreign source. So there is an exemption created for Indian companies which are complying with FDI. The reason being that if a company is not meant to fall under two laws. So if 51% of your shareholders are foreign residents and you're an Indian company, and you're complying with Indian FDI laws, then you can make a donation to an NGO or a charity without filing for FCRA. Then the registration requirements for FCRA are again a bit onerous. There are two things. One is that either you register yourself as an FCRA entity, or you don't register yourself, but you get permission every time you want to raise foreign funds. For registration, the requirements are very clear. The objective must be you must have a definite cultural or economic or educational source, educational objective. You must have been in existence for 3 years. So a new NGO or a new charity will not be able to register for FCRA. They have to have a 3-year track record. And in the last 3 financial years, you must have spent at least 15 lakhs on your core activities. So the 15 lakhs will not include your administrative expenditure. It will only include any expenses that you would have made in fulfilling your core activities. And again, there are other more substantive requirements, is that you must not have been prosecuted. The entity must not have been prosecuted. An officer of the entity must not have been prosecuted for certain offenses. The entity must not have been convicted by a court for misutilizing its funds or diverting its funds. The entity must not have been prosecuted, and this is important. It's not just convicted, but prosecuted for creating communal tension or disharmony or anything which goes against the sovereignty of the Indian state. Any entity which falls under all of this would not be eligible for FCRA registration. And as you can see, this is worded very broadly to give a lot of discretion to the government, and because a lot of things can fall under sovereignty of the Indian state, right? If a charity or an NGO does not meet the requirements for registration, then they can still raise foreign money or they can still receive grants from foreign sources, but then they would have to apply for permission. And the problem with permission is that a registration, once it is granted, an NGO can keep on raising money from foreign sources. They don't have to keep going to the government again and again. But when it comes to permission, there is no one permission which will be granted forever to raise funds for the entire year or for 2 years. A permission is very specific, it's very limited, and it will be granted only for that one time to raise a certain amount of money from one foreign donor. If you want to go, if 2 months later an NGO wants to raise more funds from another donor, they would have to go back again. And get a fresh permission. They would have to go back and get a fresh permission, even if they want to raise more funds from the same donor. So a permission is one time. It's very specific. It will not be granted as an omnibus approval. So which is why between permission and registration, a registration is definitely easier, because otherwise for permission, it can easily take 6 to 8 weeks at a minimum. And that's the minimum, because in practice, it can go on for the process can take much longer. And every time an NGO wants to raise funds, it's just not feasible to keep on going for permission. So which is why a lot of NGOs, if they want to raise money from foreign sources, they would prefer to register themselves under FCRA and not keep on going for permission. The registration process itself it's actually very straightforward. You would just, you need to have an FCRA account. Now, an FCRA account can only be opened with one bank. with the State Bank of India and the New Delhi branch. You cannot have an FCRA account in any other bank or in any other branch. Now, that does not mean that an NGO cannot transfer money from their state bank from their FCRA account to another account. They can do that. So, for example, an NGO is set up in Bangalore in Kerala, and they want to use their funds in Kerala. They have a bank account in State Bank of India, Kerala, perhaps. They cannot receive foreign contribution in that bank account. They will have to open a bank account with the State Bank of India in New Delhi to receive to receive foreign contribution. But once they have received that amount, the funds can be transferred to their other bank account for operations. So the purpose of saying, so when we say you must have an FCRA account, it must only be in the State Bank of India. It is not that all your funding will have to be deployed from State Bank of India. That's not the case. That is, the FCRA account is only the account where you are allowed to receive foreign contribution. So you would need to have an account with the State Bank of India. You would have to, you can create a login ID online. It's called, I think it's FCRA Online is the link. You fill up the application form, and you will need to provide certain documentation, which is a certified copy of your registration certificate, like if you're a company, if you're a Section 8 company, for example, that's your certificate of incorporation. The documents or the relevant pages of your constitutional documents, which is your memorandum of association, your articles of incorporation, depending on what kind of NGO you are. There has to be an activity report which is provided, which sets out all details of the key activities that the NGO has undertaken for the previous 3 years. And you would also need to provide copies of your audited accounts. And this is very important. The fees is, I believe, the fees is very less. It's about 1,000. It's about, I think, it's about 5,000 INR for registration, and for renewal it's 1,500 extra each time you renew. Registration is usually granted for 5 years and must be renewed 6 months before expiry. So once you have filled up the application, done all of this, the MHA is going to assess your eligibility for FCRA registration. And in addition to the eligibility criteria, they will also look at what kind of benefits the NGO, what kind of impact or what kind of benefits the NGO has made or provided in their chosen field. And the MHA would also examine whether this NGO, if they receive foreign funds, is it going to prejudice the sovereignty of India or the security of the country, or will it be against public interest for this NGO to receive foreign funds? And again, as I said, the wording here is very broad, because the purpose of FCRA is to essentially regulate what kind of donations are coming into India and from what sources. Once you have registered, even though once a registration certificate is granted, even though it's very easy for the NGO to keep raising foreign funds again and again, MHA still has a right to review it. Or sometimes if State Bank of India or whoever, the authorized bank which is accepting the funds, if they have reason to doubt the source of your funds, they can still withhold that amount. So it does not, just because an NGO is registered under FCRA does not mean they are entitled to receive funds. Any funding can still be subject to review by the Ministry of Home Affairs or the authorized dealer bank or the Reserve Bank of India. But it's just that the process becomes easier in the sense that you don't have to keep going again and again to get a fresh permission. Now, if by chance the registration is not granted, then an NGO cannot make a fresh application for the next 6 months. Once a registration is granted, there are a lot of compliance requirements that need to be kept in mind. One question that I have seen, though not always, is whether funds that you receive as a foreign contribution or whether the funds that you receive from foreign sources, do they need to be used only in India? For example, what if it's an NGO which wants to provide services outside of India? or undertake some charitable activities outside of India, but it just finds it easier to raise money into their into their Indian branch. Is that permitted? And I understand this is not a concern which most NGOs have, because they are usually set up in India to operate and deploy funds in India. But for some larger institutions, I have seen this question coming in. The law does not say anything. There is no case law as such. The FAQs of the MHA, they don't clarify, but there is something known as an FCRA charter on the MHA website. It's not binding, it's guidelines. It sets out guidelines that need to be adhered to, but that makes it clear that from there, it seems like funds should only be deployed in India and not abroad. Then the second question is, what I've already answered. Can you have several accounts? For example, you're deploying funds in Karnataka, in Kerala, in West Bengal, in Assam, and then also in Uttar Pradesh. Would you have to deploy funds from the same FCRA account throughout? No, that's not required. To utilize your foreign contribution, you can open additional accounts, but you must but there would have to be an intimation which goes to MHA within 5 days of opening the additional account. Then what are the annual compliances? Is there anything that the NGO needs to file with the MHA every year? And yes, there's something known as a Form FC4, which is it is similar to an annual report or an annual audited account that needs to, and sorry, it's similar to an annual return, which has to be filed with MCA every year. And plus the balance sheet, the profit and loss statement, the financial statements of the NGO must also be filed. If an NGO has not received any foreign funds in that year, like for example, you have an FCRA registration, you have an FCRA account, but in that year you have not really received any foreign contribution, even then you would need to file the Form FC4, but it's something known as a nil return. So essentially, once you have registered yourself under FCRA, there is no escaping the ongoing compliance. And this is what allows MHA to keep an eye on who the donors are, what the money is being used for, and how much money is coming into each entity. I think and the NGO, the books of accounts that you maintain for any foreign source, they must be separated from the books of then your domestic books of accounts. So all foreign funds, all foreign contribution, they would have to be recorded separately from funds that you receive from domestic sources, and you would have to maintain these. You would have to maintain these. I think you have to maintain these books of accounts, and you have to maintain all the accounting statements that you are submitting with your Form FC4 for 6 years. So because at any time during these 6 years, there can be an audit over you. Then another question is, can an FCRA funds be transferred? And earlier, before 2010, there was this broad permission which was granted to all FCRA entities, where it said that an NGO can transfer foreign funds to another NGO which has an FCRA registration. But now, after 2010, there were certain amendments made to the Act, and after this, transfer of foreign contribution is absolutely not possible. Now, this has two implications. One is that, of course, if the NGO which has received the foreign contribution is the only entity which is allowed to deploy and use that foreign contribution. And the second, and it's something which is not very instinctive, is that this also means that FCRA funds cannot be returned. Now, we have seen instances where sometimes, there are funds coming in from foundations abroad, foundations which have very strict requirements, where if the receiving entity, if the NGO has not used up all of their funds, all of the grant money during the specific period, then whatever's left would have to be returned. But under FCRA, there is actually no mechanism to return your funds. It's very difficult. There is the no transfer restriction is blanket. It applies to both returning funds to your donor. It also applies to transferring any funds to any other entity in India. And we actually, with I Pro Bono, we actually saw an instance of an NGO where they were in trouble because there were funds, the funds of the donor in the US had been frozen, and they could not make donations anymore. And the donor was now asking the NGO to return whatever grant money had not been used because the project had been frozen. And they were in a fix because they couldn't, as per FCRA laws, they couldn't, there was no mechanism to return the funds. And your AD Bank, the State Bank of India, will not allow you to transfer this money out of India. There is theoretically the only possible way to do this would be to file an application under Section 50 of the FCRA, which gives discretionary power to the government to exempt any provision of the FCRA. So theoretically, if an NGO is in a situation where grant money has to be refunded, then yes, it would where grant money has to be refunded, then you can apply to MHA for the exemption, explain your circumstances, but in practice, it's not something that I have seen at all. And I'm sure I'm not even aware of anybody who has actually gone down this route or anybody who has opted to where this situation has arisen, because I think the NGO that I had worked with, where they had to return the grant money, I believe they're still working on resolving the issue. But it's a Section 50 exemption, especially for return of foreign funds. It's not something which can be easily granted by. It's not something which will be easily granted by the government. And also the process is not simple, because even though on paper you file an application, you give your reasons, you submit it, the application will not be processed unless there is a consultant that you have hired who can actually go and liaise with the government, who can give you updates, who can provide any additional documentation that the government needs. Without a consultant who knows how the government works, who knows how the ministry works, who has done this before, it's very difficult to get these exemptions from FCRA, because it's a law which is very it gives a lot of discretion to the government, and it's also applied by the government very, very strictly. Other than this, I also see a lot of questions on what else is prohibited, or what else should one keep in mind under FCRA. And a lot of organizations prefer not to be registered under FCRA because they would not want because the compliance requirement is too high, right? And from a cost perspective, it just does not make sense. Filing accounts every year, having your accounts audited by the ministry every year, or at least having your accounts being in the public portal every year, it's not something which all NGOs would prefer. So a lot of NGOs choose not to opt for FCRA registration. But the question of when should you go for FCRA, when should you not go for FCRA, really depends on what donors are you looking to attract, of course, but also what do you think how much do you want to scale up? Because if you want to remain, if it's a smaller NGO which does not want to attract foreign funds, which operates an activity, which undertakes an activity where they believe they can receive they can receive domestic funds, where an NGO which does not perhaps want to scale up as such, then yes, then an FCRA registration does not make sense from a cost perspective. But if it's an NGO which wants to provide services across India, which wants to conduct operations across India, which wants to scale up, then an FCRA registration would be beneficial, because it just allows you to tap into foreign sources. And there are nowadays a lot of organizations who are looking to donate to India, who are looking to give grant money into India, because there is a lot of organizations, they see, and especially US organizations, they see a huge scope in India for their philanthropic activities. So it's relatively easy for Indian NGOs or Indian charities to attract foreign money from foundations, or even from foundations or trusts or even educational institutions or medical institutions from outside of India. And if that's the kind of source that you're looking at, then yes, an FCRA registration would does make sense. And perhaps the cost of compliance and all the cost of compliance, all the limitations and restrictions which come with FCRA, it from a cost benefit analysis, it would make sense if the basically if your main objective is to just attract a certain kind of capital. I think that's it from my end. I think the only last thing is that it's again very procedural. If you what if details of the NGO changes? For example, the location changes or the address changes, or the members of the society change, or there's any amendment to the documents. Is there any notification requirement to the government? And the answer is yes. There's a specific form which is given. I think it's form 6A, 6B. There are a couple of forms which are given depending on what kind of change it is. So if you have changed your address, or you have changed your objective, or the members of your company or society or the trustees have changed, then you would need to intimate MHA in the specific forms which are given in the Act. Again, while FCRA, I understand the requirements are onerous, and it is very compliance heavy. It is also standardized. It's not unlike the Societies Act. You don't have state specific forms or district level officers who apply the law differently. It is actually it's a central act. It's very standardized. All of the forms are very easily available on the website of MHA. And in the last few years, it has been very effectively digitized, which means it has been very effectively digitized. So almost everything is now online. So even though the compliance requirement is high, it's not overly burdensome. It's relatively easy. Everything is easy to access. The only issue would arise is of course, if you want exemption from certain sections of FCRA, then that's not something which comes by easily. But regular day-to-day compliances are not that onerous. So I think that's it from my end on FCRA and the presentation. And I think
Thank you. Thank you, Ranjini. We just have a few questions which we already have in the chat box also. But also I wanted to ask, you've mentioned about the fee which is required for the renewal, and also the documents which the NGOs have to maintain throughout. But is there anything else also during the renewal of FCRA which is required for the NGOs to be done?
No. Basically, you have to file the application again, and the supporting documents which you provided the first time, your activity report, use of funds, your memorandum. So some of these things may need to be provided again. Essentially, your activity report and use of funds is something that does need to be provided again, but yeah, but not really. But yeah, so it's just a documentation requirement. There's nothing else really that you need to have done.
Okay. Another one is what we've heard of and what we've got queries of is when the funds which we've received are frozen. So what can be done then?
That's actually very difficult because I have seen this, but I have not seen a case where funds which were received were frozen, and I have not really seen a situation where they were later unfrozen, because MHA unfortunately maintains discretion, a very broad discretion over whether an FCRA entity can even receive funds at all. And they have been very clear, and I think even the Supreme Court has very clearly said that just because you have an FCRA registration does not mean you're entitled to receive funds. Your funds can still be withheld, they can still be frozen. Yes, there is a process. You can appeal to the MCA, you can appeal to your AD bank, but it's just that you have to follow the due process. And if funds are frozen, there would be questions raised, there would be a show cause notice sent. So it's just a matter of following the process. But apart from that, there's very little that can be done. And even here, it's recommended that you have a CS or a consultant who's helping you, because they know how MHA works. They know how the law is operated. They know what concerns are there. Even though as I said, the law is very clearly laid out. It's a standardized law. There are still nuances that most people wouldn't know because it's not out there in the public domain. And case law on FCRA is actually very little, is very limited. Most of the case laws are on larger constitutional questions, but not on the operational aspects of FCRA, which means the day-to-day practice, how MHA interprets specific provisions, what kind of issues they usually raises, what kind of issues raise red flags for them. All of that, these are things that you would need a practitioner or a consultant to help you with.
Okay, thank you, Ranji. We have a few questions in the chat box. The first question is, can the society purchase land through FCRA funds? If yes, what will be the situation if later in future FCRA of the society gets cancelled?
That is interesting. I think there's nothing stopping a society from purchasing land using FCRA funds because it's an Indian society. Of course, there are other restrictions, but there's nothing stopping a society. And even if the FCRA registration is later revoked, nothing happens to funds which have already been received and deployed. It's not that the funds would have to be returned or that the funds would have to be or that the funds would be remanded by the government of India. Anything which has already been deployed, that doesn't affect it. But FCRA revocation only means that future funds cannot be received, but anything which has already been received, which has already been utilized, doesn't really need to be, can't really be frozen. And yes, there's nothing stopping a society from purchasing land using FCRA, but of course, it would need to fulfill the purpose of the grant. So it cannot be land for private use. It has to be land, for example, for starting a school or starting a hospital. The purpose must be the object, must match the objective of the society, and that is the only real criteria.
We'll move on. Yeah. Should I just?
Yes, I'm
Thanks,
just
Ranjini. So I think the next question is, do we need to have ATG certificate for FCRA registration?
No, not necessarily. Not necessarily. I think you need to have your incorporation documents need to be registered, but I don't think you need to have an ATG registration. So they govern different aspects. FCRA is only to regulate foreign contribution. And if you're but it's not necessary for all charitable entities to have an ATG registration. Of course, it's beneficial, but it's not necessary. Just while we're on that question, if you're an entity, if you're a trust or a society which wants to act as an implementing entity for CSR, because nowadays, as I said earlier, a company, if they want to deploy CSR funds, it's not enough for them to only give the money to somebody. They have to actually conduct the activity. They have to maintain oversight over the activity. So they usually appoint NGOs to be their implementing entities. For that purpose, you would need an ATG and a 12AA registration. It's very clearly set out in the Companies Act. But for FCRA, you do not.
Okay.
What would we do?
Yeah. What should an organization do if they receive some foreign funds without FCRA?
I think I would be very surprised if an organization has received foreign funds because all foreign funds which come into India have to come in through an authorized dealer bank. And an AD bank will not allow a foreign grant until you have shown them their FCRA certificate. So an AD bank it's not something I have seen happen. It's not possible because AD banks are very strict in their compliance, and they should be because the liability is theirs if they've allowed funds into India which were not compliant with Indian laws. But I'm not sure which bank would even allow this in the first place. So.
What if Ranjini, in certain cases there are these subgranting agencies where organizations subgrant, and in that case maybe some of the organization who has FCRA has taken some money and then subgrants. Is that possible?
Yes. That's no longer possible. That's no longer used to be possible but only if you could grant to another FCRA entity, but now it's no longer possible. Because so essentially transferring FCRA funds is no longer possible. So subgranting would fall under that. You can transfer the money to your own account because you're going to, or you can transfer the money to fulfill your objective. But basically, an FCRA entity cannot be a conduit where they're receiving funds from someone and then just subgranting it to somebody else. They can no longer function as a conduit. That's not allowed anymore.
Ranjini, the next question is, do we need to have the FCRA account in any particular branch or any SBI branch in Delhi works?
No, it has to be I think it's the SBI branch in New Delhi, if I'm not sure. The central branch in New Delhi.
Okay. The next question is, if the Indian office of a foreign company gives donation or grant to an Indian NGO, shall it be considered as FCRA as source?
Depends on what you mean by an Indian office. If you're an Indian subsidiary, then and of a foreign company, then as long as you're holding the capital in compliance with FDI laws, it will not be foreign source. But if you're a branch office or a project office or a liaison office, then yes, it's possible that it could be a foreign source. Yeah.
We have the next question where they've received a show cause notice regarding cancellation of FCRA. Those they did not receive during the FC during 2021-2024. So they're asking, is there any provision to, like, without cancellation, or what should they respond to the notice?
I mean, so basically, I think, am I correct? It's a cancellation notice because they did not receive any foreign contribution from 21 to 20 in 3 years. Is that the
Vijay, if you're
reason
there
for
on the
the
call, Vijay, if you're there on the call, please go ahead and ask your question. It's the question by Vijay Raj. Are you there on the call, Vijay?
He's on the call. I've asked him to answer.
Yeah, hello, madam. Yeah, this is Vijay, madam.
Hello, yeah.
Yeah, during that 3 years, we did not receive any funds, madam. For that reason, we received a show cause notice from MHA. Is there any provision how to explain to that notice? Could you please help me, madam?
I think the best way here would just be to respond to the notice. It's not something you should ignore. And show cause notices from MHA are not things to be taken lightly or to be ignored. And I think your best course of action would be to explain why you did not receive funds. Basically, I think what the government is trying to say is you are FCRA registered, but you're not raising funds from abroad. So basically, your registration or your certification should be defunct, right? It's not serving any purpose. But I think the best, you would have to explain to them why you did not receive funds, and it can be that you did not tap into those sources, or you thought you received sufficient funds from domestic sources, so you did not need to go to foreign sources. So you need to explain why you did not receive funds, and also explain why you think you should keep the registration. So basically, are you looking at foreign sources in future? So it's a show cause notice. I mean, I think the best way is to just explain exactly what the reason was, and why. Basically, you have to explain to them why you should be allowed to keep your FCRA registration even if you haven't received funds in the last 3 years. That would be, at least that would be the kind of response that I would advise to send.
Right, man. I agree with you because I have mentioned same like this. I prepared already show cause notice. What you said, everything.
Yeah.
Is there any Supreme Court order if they unfortunately cancel my FCR? Is there any provision? Is there any Supreme Court order to challenge in the Supreme Court, madam?
There is an appeals process, but I would have to look it up. There is I think there is a process under the law, but it's not something I know it's not something I know offhand, but I would have to look it up. I mean, there is a way to do it, but you would have to look it up. But I mean, if you respond to the show cause notice, it's likely that it's a show cause notice is not an order of revocation. So if you have explained it clearly enough, then it's not necessary that your registration will be revoked or cancelled.
Ranjini, if you don't mind, if we can get in touch with Vijay separately and try
Sure.
to help him.
We
Vijay,
can do
please write to us, and we try to take it up as one direct legal support project under our vertical, and we'll see if we can help you in any way. At least review your answer, a response to them.
Yes, yeah. Yeah, I think I can see the next question. It's about if the donor can refund the fund from refund the money to an FCRA to the F. I think you want if the donor wants the FCRA entity to refund the money, and unfortunately the answer is no. FCRA does not allow funds to be sent back. FCRA does not allow funds to be transferred at all. So the process would be you go to under section 50 of the FCRA, which is you take a special permission from the government to be exempted from certain provisions of the FCRA, in this case being the no transfer requirement. And you explain the circumstances why the donor wants the refund, what is the requirement and what your grant letter says a lot of times. And this is the kind of fine print which a lot of NGOs miss. The grant letter will say something like any funds which are not deployed in this particular year will have to be refunded. And nobody looks at it, right? Nobody thinks that refunding can be a problem because the donee always feels that even the donor, it's a standard language sometimes. Even the donor hasn't thought of it because the situation where money has to be refunded arises very, very rarely. So everybody misses this, but sometimes if it's invoked, then that's when the trouble starts. And then you're in a situation where you cannot refund the money because the law doesn't allow you to, but the grantor or the donor wants the money back because your grant agreement or their own bylaws or their own funding requirements say that they have to get the money back. And unfortunately, there is no process under the law. You have to go to the central government to the MHA for a special permission.
Ranjini, the next question is basically they're facing some difficulties in updating the CSR1 certificate. They've just changed the organization name and the new name is reflecting in the important documents, but they are facing difficulties in updating CSR1 certificate.
I mean, what is the difficulty? This is CSR, right? So this is your implementing entity registration. It's not your FCRA. I mean, Karuvaki Amla, perhaps we can reach out to them separately because it would help to know exactly what the reason is and why it was. Yeah.
Suresh, thank you for your question. You please reach out to us separately. I'll just type down the email ID for Amla, who's also with us on this call, and we'll try to get on a call separately with you and to figure how we can help or if there's anything that can be done. If anyone else has faced this and has somehow, been able to navigate this, then please let us know. Your suggestions are welcome.
And I think the last question is that, sorry, please go on. Amla, you were saying something.
Yeah. No, I was just reading out the question for you.
Yes, it's silent on many protocols how to get clarity. Unfortunately, it's the the MHA FAQs are one source. They actually do clarify a lot of information. So something like if you're a Section 8 company and you have a foreign investor, is it FCRA or is it FDI? These are things which are actually clarified in the MHA FAQs. But again, I think Amla, Karuvaki, we can share the link because there are two sets of FAQs and there is only. But so you would need to go to the MHA website and go to the link through that specific FAQ. Like go to the link for I mean, there are two sets of FAQs on the internet. If you just say FCRA FAQs, two sets will come up. And they look exactly the same, but there's only one which is linked from the official website of MHA, and that's the one that's more credible because that's the one that has your Section 8 question. So MHA FAQs, again, very helpful. Supreme Court judgments are helpful, but they're mainly on larger constitutional aspects, so you don't get a lot of clarity there. The FCRA charter, which I believe is in the MHA website, that is also helpful in the sense that they give you it's called the Charter for Associations who've been granted prior permission under FCRA. Again, that's very helpful in the sense that it's not binding, it's just guidelines, but sometimes those guidelines do clarify what the intent and spirit of the law is. So even though they don't give you the exact answer that you're looking for, they may provide clarity on how the FCRA scheme works, and then from there you can interpret that because this is how this is what FCRA is intended to do, or this is how FCRA's interpreted or operated by the government, these things are unlikely to be permitted. So sometimes the guidelines are also very helpful. I have seen NGOs trying to approach MHA to get clarity, but that doesn't always work because sometimes they just don't get answers. If it's an issue, I mean, if it's an issue that you're facing, then you may sometimes also speak to a consultant or an AD bank. They sometimes can help you as to how to interpret certain provisions of FCRA. So sometimes a practitioner, a consultant will have, the day-to-day knowledge, like which is not available in the public domain, but they may be able to help you. But unfortunately, there is no one right answer, or there is no one source as to how to get clarity, because you are right, it is silent on many protocols. It's clear in a lot of ways, it's standardized, but there are once you actually start receiving funds, a lot of these questions come up, and FCRA doesn't always clarify. That is unfortunate here.
Thank you, Ranjini. There's one very interesting question from Nikhil. He says that they are registered as a society and have an FCRA license. They use that funding to purchase certain assets, and now because assets have gone outdated, they have sold those assets, and now they have received money from the sale. Where do they deposit this? In the current SBI FCRA account, or the older one, which was a BOI account, which is still active? But where can they actually deposit? Can they deposit in the older account or not?
I think that's a very interesting question. You're right. And I think perhaps, Nikhil, if we can also reach out to us separately, to iPro Bono separately, they may be able to help you better. My initial thought would be you don't need to deposit to the SBI account, because foreign contribution, and I'll go back to the slide. Foreign contribution is defined in a way which is a bit narrow. It says donation, delivery, or transfer made by a foreign source. And if you used FCRA money to buy a land, then you sold the land, that's not proceeds from a foreign source. So from an absolute from a technical reading of the definition of foreign contribution and foreign source, you don't have to deposit. This will not be FCRA, and you don't have to deposit it in your SBI account. But this is, I think, a question which merits a little bit more research. But yes, no, but from a purely technical reading, my initial answer would be you don't need it. This is not FCRA, because the definition of foreign contribution is very clear.
Thanks, Ranjini.
Yeah.
Nilesh is asking if they can take FCRA funding or money in their personal account.
No. You would have to, the SBI account will have to be in the name of the FCRA registrant. So not in your personal account. That's not permitted. Yeah.
I think this is it. All the questions. If anyone has any other question, we have like some 10 more minutes. So
Yeah.
please raise your hand and go ahead. And if there's anything that you want to share as your experience in terms of like getting an FCRA or registration done, anything that anyone has faced, wants to share with the group for that can help us, then we'd be happy to take on a couple of more questions.
You can. I think Nikhil has a question. Formed a society. Now you're thinking of forming a Section 8 company, same name, same members. Yes, there's nothing stopping you. You would have to, the only thing is that you would have to, when you go to reserve your name with ROC, they will run a check to see if somebody else exists with that name. I'm not sure if they'll only look at companies or if they'll also look at societies and trusts existing with that name. I don't think so, because sometimes you will notice larger groups, they have similar names for their companies and for their non-profit verticals. Like Mahindra, for example, the Mahindra group has societies and Section 8 companies, and they're named very similarly. So perhaps it won't be, but that's the only thing that I would be a little careful of. That you go, MCA will run a check to see whether the name exists, but even that is easily solvable, because if it's your society, you can easily give a no objection letter from the society allowing the company to use the name. So there's nothing stopping you, and yes, you can run both. There's nothing stopping you from doing that either. And yes, the members can also be the same. There's absolutely nothing. There's no restriction on this at all. Yeah. It's just that when you're forming a Section 8 company, like I said, the name and then the brand name, the trademark, who owns the logo, the name, things like IP questions, those things will come up. But under law, there's nothing as such which stops you.
Jayesh, if you have a question, you can please unmute yourself and ask.
Yes. Hi. Am I audible?
Yes.
Yes.
So first of all, thank you everyone for having this session, and it was quite useful and so productive.
Thank you.
So Ranjini, I just have a small question. I just want to know, we have a society in Goa, registered in Goa. Basically, I just want to know whether Goa has a state body law which operates, I mean, or controls the society. I don't know, because you confirmed about Maharashtra and Gujarat. So I just wanted to check about Goa.
I think Goa is a society. Hello? It's a society, right? In Goa, it's not the trust.
Ranjini, it's the same organization you had helped them with the FCRA refund fee.
Understood. Then yes, Goa does have a specific Societies Registration Act. So Goa doesn't. For a society, it's governed by the Central Societies Registration Act, and which has state amendments, but some states have also passed their own Societies Act. But either way, if you're forming a society, you will be governed under some law. The Maharashtra Gujarat example was only for a trust, a public charitable trust. Maharashtra and
Okay.
Gujarat have specific laws, yeah, but the
Okay,
rest
okay.
of other states don't, yeah.
So if we have, I mean, Goa has their state governing body, then I just have a last question that if suppose society want to sell a property, which is, so do we need a written permission from the state or court or anyone?
I don't think so, no. You
Okay.
don't. And I think somewhere in the law, there will be a provision about what to do with the proceeds, because the central law says that proceeds will have to come back to the society. I
Mhm.
think Goa will also have a similar clause. But you don't need
Okay.
permission as such. Yeah, I don't think so, at least. I mean, of course, I mean, yeah, I don't think you would need permission for something like this. Yeah.
Okay. Uh, at the last, if I mean, I mean, as I asked earlier as well, that FCRA is and MHA are silent on many things, and sometimes we just stuck. I mean, what to do next on that things. So, as you said that that FAQs, we have read that FAQs as well. Even referring them, we can't find. We will not able to find the solution. In that cases, what we can do? I mean, I don't know. And
In that case, you need to liaise with MHA. That's the only solution left. Because if your FAQs can't help you, if the law doesn't help you, then you would need to approach MHA and ask them your specific questions. And I understand it's not the easiest, because sometimes they don't answer.
yes. Mm,
And
I
even
know.
if they answer, it's not binding, right?
Yeah.
MHA, it will depend on which officer of MHA you have got who has answered your question. But that's the only thing. There's nothing else really.
Yeah, they just reply a standard, answer, and that's it. Some standard link or PDF they will send, and they just close the matter.
Understood. Then I think more than writing to them, having somebody, like I said, which is why it's so important to have a consultant or a practitioner who knows this, that you may get more answers if you get somebody to liaise. But I understand that's a cost, and if sometimes it's a cost which not everybody can bear. I'm fully aware of that. But if you getting answers like by yourself is not working, then the only other option I would say that is left would be to engage somebody who can get these answers for you. somebody who can actually liaise with MHA to get these answers for you. And there are consultants who do this. They charge quite a bit, but they're not always successful. Not everybody is always successful. It's it is a law which is ambiguous.
Thank you. Thank you, Ranjini.
I think we have our last question, Ranjini. After that, we can wrap up this session. If you can take the last question, it's from Pallavi. She wants to know if they want to register an NGO, under which one is for trust, society, or Section 8 company.
I think, Pallavi, thank you for your question. So the answer really is, what is it that you're looking to do? How big is your organization? And what is your priority? If a trust, as I said, is relatively simple, compliance wise, flexibility wise, it's dissolution wise, registration wise, a trust is very, very simple for, especially if you're a smaller NGO, you're just starting. But a trust also has it's a very opaque structure. So sometimes you may not be able to attract sophisticated enough donors who want a lot more transparency or who want a lot more credibility in the organization. So yeah, it really, again, as I said, it would really depend on your objectives and your priorities, and also the tax benefits that you're looking at, because a trust society and Section 8 company are all taxed separately. And I'm not a tax expert, so I cannot go into detail, but tax consideration is one thing which you may need to keep in mind.
Also, if I may add, Pallavi, there are a lot of compliances that will take more time and energy if you go for a Section 8 company, whereas if it's a trust and society, as Ranjini had also like covered earlier, it'll be a little easier for you to actually form it and operate it. Whereas on the other hand, it'll be easier for you to, when a funder, which is like a big funder, like say, for example, a funding organization in India, which is funding like most of the organizations, they will, be more relieved to give funding to a Section 8 company because they know the compliance is already done. And if it's a trust, they'll go into more details of how you're using the funds. So if that answers your question.
Yes, yeah. But just to clarify, it's yes, foreign donors may prefer FCRA. Sorry, I did not share the last link. Yeah. So just to clarify, foreign donors may prefer a Section 8 company, but that's not to say that a trust will never receive money from a foreign donor. As Karuvaki very rightly said, they may go into a little bit more detail. So their accounting, their auditing, their oversight may be a little bit more detailed, but it is absolutely possible to raise money through to raise foreign funds from an FCRA. And I will just share my screen because I realize now that I missed doing this, but I think this is the link that.
I think we have one last
think
question.
one more,
Since it's
yeah,
from
there's
Pragya,
just-
we can take that up.
Yeah.
Under which category one should register social enterprise? I already have a society whose scope of work is for medical rehabilitation. So Pragya, is your question? Pragya, you can actually unmute yourself and ask, do you want an additional registration of a social enterprise along with the society that you already have? Is that the question? Not able to unmute.
Wait, I'm unmuting you.
Hi, Rajini. Hi, Karuvaki. So I'm sorry I joined a little late, but I already have a society whose scope of work is medical rehabilitation and education support and all. I also want to register a social enterprise. So and I of course don't want to merge these both as of now, because the society has been running from more than 12, 13 years, and a different. So what do you suggest? Should I register a separate register it separately as a social enterprise, because there would be transaction, there would be it's a different uh, 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 you know
Understood. Yeah. So there's actually no one legal structure for a social enterprise in India, but I think it would maybe a Section 8 company in this case would benefit you.
Okay,
You're
so
saying, but if you don't, yeah.
so while I was researching about Section 8 company, so there were different kind of opinions, and some people, some of them, they said that, you might not be able to get grant, especially government grant, in a Section 8 company. Is it like?
No, there's nothing. No, there's nothing. There isn't really stopping it. No. I mean, yes. See, at the end of the day, it is also a charity. So it shouldn't be difficult to get it. I mean, I've at least never heard of government grants being difficult for a Section 8 company.
Okay. Okay. And when I compare LLP and Section 8 company, which one should be better for, a social enterprise? Again, it's a long, huge,
Yeah.
debate. Yeah, debate. And I have been struggling with it from past two
Yes, yeah.
months, different opinions from so many different people. So, yeah, but
See,
just,
to be very honest, I actually have no opinion on this. I think an LLP is more tax efficient,
okay.
right? From a tax perspective, I think an LLP would help. But from a purely social enterprise perspective, I'm not entirely sure if I can advise you. I mean, offhand, if I can advise you without considering it a little bit more. And I know an LLP is more tax efficient, so that may benefit you. But I think I'm not sure. But I think at the end, a Section 8 company may still at least be may still be a little bit more beneficial because you would have incorporated it with a specific social objective. So it may aid in it may help you get the registration a bit easier. But I'm sorry, I wouldn't be able to advise on this offhand.
Okay. So, in your experience, most of the social enterprise, they are registered under Section 8, or?
I have seen Section 8.
Okay.
Yeah. But I've seen very few. Just to caveat it, it's not that I've seen a lot and they're all Section 8. I have seen very few, but I have seen Section 8.
Pragya, actually, we can talk about it a little in detail also later. Maybe we can take help from Ranjini or someone else, maybe one of our, the CA firm that actually guides us. I can ask
They may be better, yes.
one of our operations, we can ask our operations director to put you in touch, Pragya, with them, and maybe they can help better
That will be
on this
That may be
question.
better, actually. Yes, that's correct, because it'll be a compliance and tax question, and they'll be better suited to help you. That's correct. Yeah.
Thank you.
Thank you so much, Pragya. That was the last of our question. I'd like to thank you again, Ranjini, for your time and for doing this pro bono. This was very insightful and we've learned so much today. For everyone here, if you have any questions for Ranjini or if you'd like to reach out for any other legal queries, we've sent Karu and my email ID on the chat box. You can reach out to us with any of your legal queries. Please scan the QR code and follow us for any updates or if you want to get in touch with us. Thank you. Thank you so much.
Thank you.
Thank you all. Thank you, Ranjini. It was very, very helpful.